Item 3, Business Trust Amendment Bill.
Mr. Alvin Tan.
Mr. Speaker, sir, on behalf of Mr. Tharman Shanmugaratnam, Senior Minister and Minister in charge of the MAS, I beg to move that the bill be now read a second time. The Business Trusts Act 2004, or BTA, provides a framework for the governance of registered business trusts, which are enterprises that combine the characteristics of both a company and a trust. The BTA also facilitates the use of business trusts as listing vehicles and is a new asset class for investors. But unlike a company that can only pay dividends out of its accounting profits, a key feature of a business trust is the ability to pay dividends out of its cash profits. Now, this makes it particularly suited to businesses with stable growth and a high cash flow, such as infrastructure businesses. Now, many requirements in the BTA were adapted from the Companies Act, and the bill proposes updates to the BTA that are consistent with amendments that have been made to the Companies Act to enhance the regulatory framework for companies. In addition, MAS has also identified other legislative amendments that are needed to maintain the robustness and relevance of the regulatory regime for business trusts registered under the BTA. Mr. Speaker, sir, I will now go through the key amendments in the bill. Let me start first with the amendments to better align the BTA with the regulatory regime for companies, and these are mainly in three areas. First is to enhance the transparency and corporate governance. Now, the bill introduces requirements for unlisted business trusts that are registered under the BTA to obtain and maintain information on their controllers, also commonly known as beneficial owners, and to also provide such information to MAS and other public agencies upon request. Now, with these amendments, unlisted registered businesses, or business trusts rather, will be subject to the same transparency requirements as unlisted companies regarding their beneficial owners. Now, these requirements will help to mitigate the risk of business vehicles being used for illicit purposes, regardless of whether they take the form of a company or a trust. Currently, directors of trustee managers of registered business trusts are required to disclose conflicts of interest in transactions, as well as their interests in the registered business trusts. Now, the bill will extend such requirements to CEOs of trustee managers in recognition of the influence that they have on the affairs of business trusts. Now, the change is consistent with existing disclosure requirements that are applicable to CEOs of companies under the Companies Act. The bill further introduces requirements for auditors of listed registered business trusts and their subsidiaries to seek MAS's consent if they wish to resign before the end of their term. It also sets up procedures for the appointment of a new auditor, where the resigning auditor is the sole auditor, including a reserved power for MAS to make such an appointment. Now, these requirements will allow MAS to prevent a listed business trust or its subsidiary from being left without an auditor. Through the application process, MAS may also be alerted to any potential breaches of the BTA and the Accountants Act. This is in line with provisions in the Companies Act in relation to auditors of public interest companies, which include listed companies and their subsidiaries. The second key area is to strengthen the rights of unit holders of registered business trusts. Currently, unit holders holding at least 10% of the voting rights of unit holders present at a meeting have the power to call for a poll. The bill lowers this threshold to 5%, making it easier for unit holders to call for a poll on issues that they are most concerned with. The bill also expands the scope of the statutory derivative action in the BTA to allow a unit holder to apply to the court for leave to commence arbitration on behalf of all unit holders of the business trust or to intervene in an arbitration to which the business trust is a party. Now, this amendment will align unit holders' rights to bring a derivative action with that of shareholders under the Companies Act. In addition, where an application to wind up a registered business trust has been filed in court, the bill expands the range of orders that the court can make, including an order to buy out the interests of one or more unit holders. Currently, a court hearing such an application can only make an order for the registered business trust to be wound up. And the additional remedy helps to protect the rights of minority unit holders, as there may be cases where the company is still viable and it would be a more efficient solution for the majority to buy out the minority or vice versa. The third key area is to improve the ease of doing business and to reduce administrative burden. These include changes to simplify deadlines for annual general meetings or AGMs and the filing of annual returns. Currently, registered business trusts are required to hold their AGMs once every calendar year and not more than 15 months after the preceding AGM, and are also required to file annual returns within 1 month after the AGM. These requirements do not refer to the financial year end of the registered business trust. The bill will align these timelines with the business trust's financial year end. The bill will also mirror amendments to the Companies Act to reduce the number of documents accompanying a set of financial statements. Now, to facilitate electronic communications by registered business trusts, the bill allows for electronic transmission of notices and documents with unit holders' implied or deemed consent, in accordance with the trust deed of the registered business trust. Now, currently, a registered business trust wishing to publish notices and documents on a website can only do so with its unit holders' express consent. The amendments will help to increase efficiency in this regard. Mr. Speaker, I will now cover the next set of amendments, which are to strengthen governance standards and safeguards for registered business trusts, taking reference from the regulatory regime for real estate investment trusts, or REITs. Now, business trusts are structurally similar to REITs in that both are trusts constituted by a trust deed, and unlike companies, are not legal persons. Both are also usually managed by an external manager. Business trusts are managed by trustee managers, and REITs are managed by REIT managers. Now, this external management model introduces governance risks, such as potential conflicts of interest between the external manager and also unit holders. Now, unit holders' ability to vote to remove the external manager is a fundamental safeguard against such a risk. Currently, a trustee manager can only be removed by unit holders by way of a resolution passed by not less than 75% of the voting rights of all unit holders present and voting at the general meeting. For REITs, there's a lower threshold of more than 50% which applies. So the bill will align the removal thresholds for trustee managers with that of REIT managers. This will help strengthen accountability to unit holders. In conclusion, the amendments will enhance the transparency and governance of registered business trusts in Singapore. They will streamline regulatory requirements and reduce compliance costs. This will improve the efficiency and robustness of the business trust regulatory regime, benefiting the industry and investors. Mr. Speaker, I beg to move.